Hey, 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 Gabfocus. Tommy here in Denver today. This is going to be an incredible legal episode. Melissa, how are things in Chattanooga?
Cold but great. This fall season has definitely started. So get
It's
out your
like
pumpkin
70 degrees
spice.
here in Denver. I brought my scarf, I brought my poofy jacket. I was ready for the code, and it is warmer here than back at home.
Yep. Yep. Need your scarf here today. So
So it goes. Well, y'all, welcome back to Gap Focus. If this is your first time, welcome. You chose a good episode to start because this is our annual legal update. We love to rotate through all the industry legal experts in self storage, but this one's always special to me. I think Scott, this is your fourth or fifth time joining us. Welcome to the stage, Scott Zucker. 37 years in self storage. How, tell me about that. What does that mean? 37 years in our industry.
I've seen a lot, and a lot has changed in those years. It's incredible to watch. It really is from a legal perspective and from a business perspective. Goodness gracious. I remember when I started, these buildings were temporary structures holding land for other use. Now it's fourth or fifth generation
yeah,
self-storage. So things have changed.
absolutely.
Wow. That's amazing, man. I can speak for on behalf of everyone in this audience who's live and everyone who's listening in the future. This industry would not be what it is without people like you, Scott. For 37 years, man. Thank you for your service and your dedication. I mean, the man just got back from Maine and then New York, and he's getting ready for New Hampshire, right? And so I don't know when he gets to do client work, but
I got to tell you, I love these state shows but for some reason, and you guys all know this. I mean, we travel around the country speaking to operators. There's a lot of trade shows out there, a lot of interested operators in what we're all doing. So it's great. I love talking to
yeah.
folks about the industry and about staying out of trouble. So they're always fun and they're always well attended and great audiences. Some of them laugh at my jokes, some of them don't. I try.
We need to install a laugh button
Yes.
here.
Oh, there you
There
go.
you go.
Yeah,
There you
I
go.
like it.
Hold up
Tommy,
the
you're in
sign
charge of
that says
that.
live
Yeah.
now.
Yes. Well, welcome back, Scott. Thank you for, I know you're busy. Thank you for carving out an hour to spend with Melissa and me and the rest of our audience today. I'd say let's jump into the agenda. Of course, if this is your first time at Gap Focus, brought to you by our teams at Storage Pug and Lighthouse Storage Solutions in East Tennessee. Gap Focus looks like this. We go for about an hour. Melissa and I will take turns asking questions. We have pre-submitted questions. We have a really tight agenda, but we're going to definitely make room for the Q&A, which we already have seven of before the event even started. So I anticipate more and more questions as we go along. We're going to try to talk about what's changed so far in 2024. I mean, we've had about 10 months of activity. We're going to talk about some common legal challenges, and we're going to talk about what to look forward to in 2025. And of course, for those of us who've been impacted by these massive storms that are happening in the Southeast, we're going to talk about what that means for disaster and natural disasters as well. Without further ado, Melissa, let's get it started.
All right, there are already 10 questions now in the Q&A. These people are really excited to hear from you. But before we dive into that and start chasing all kinds of rabbits, because I'm sure there's a ton of them, let's talk first about the trends that you're seeing across the states. Um, I'm just gonna, I know that's a really broad question, but
Well, from a legal perspective, and I have to give deference to the National Self Storage Association and Joe Doherty and Daniel Bryan. What they're doing legislatively is that the trend is a sort of an effort to modernize further the self storage lien laws that we have in each state, both in keeping with what has been done in the past to make sure every state has online auctions, less publication requirements, use of email, limitation of value provisions, things statutorily to support a self-storage business operator in their operation and security of their business. What we're seeing in terms of trend movement, and they've accomplished this in the last year, is solutions like terminating a tenant for non-monetary default, meaning bad behavior, destructive behavior on the property, using the property illegally, um, or in violation of the use provisions of the contract, and terminating those tenants. And then when they don't vacate, having the right to remove and dispose of the property without going through the courts. So that's a big issue. There's about 7 states now that have passed laws that allow this self-help non-monetary default remedy. So that's a great trend in the industry. And I will tell you that's because the National Association and folks like me listen to what you all are complaining about out there and the frustration you have as business operators, and they are reacting to that and doing their best to create those solutions. So the states, Utah, Kansas, Georgia, Idaho, Illinois, California, and Utah have changed their laws. Did I say Utah twice? I'll double check for you guys. But and we've got a whole bunch of states on the list going forward to change those. And I did say Utah twice, Tommy. There you go.
I was typing as you went.
I'll double check that. I'll double check. But it is a movement in terms of a trend of further modernizing the lien laws to support self-storage operators.
Yeah, I know Tennessee is on the list for next year where
There you
we're
go.
already looking at tackling it.
That's awesome,
So,
Melissa.
yeah,
Yes.
it's definitely gaining some movement there. So, I know when we've talked about it to our members already, they're like, "Oh, when can we start that?"
Well,
So,
that is just that's the problem is that you all have to be very good about double checking your state law updates when laws become effective. Even though these have passed, they're
yeah.
not yet effective in multiple states, and some of them not until January of this year or 2025, maybe not even until July of 2025. So you need to be careful about when to start invoking those. The other shift in the modernization is the ability to enforce your lease agreements, the amendments to your lease agreements with simple notice to your customers. And then after 30 days, those amendments, which might in fact be a whole new lease, become effective to these tenants if they continue to occupy the premises after notice, which has always been a gray area for many operators. Again, those same states that I've listed invoked the same enforceability of unsigned contracts after notice to the customer. So again, they're listening to you. They understand your frustrations as an operator, trying to amend the laws to deal with those issues. Now, in all fairness, and I always have to say this, I know that it sounds like it's one-sided, that these are betterments only for the operator. In truth, it's a fairness balance. It's an equalizer for tenants that share the same burden, that tenants who get leases that use self-storage have the obligation to sign those leases or leave. And if they don't leave, then they should be bound to those terms and conditions. So it's creating a fairness balance. And I think the legislators in the different states have recognized that.
Well, and
I
Anne
love that
Marie
you point that
said,
out. Yeah.
oh, sorry. Anne Marie said it's also better for the rest of the tenants that are actually following the lease and following all the rules.
Yeah.
It's making it a pleasant place for them to continue to store. So,
Yeah.
sorry, Tommy, what
Oh,
were you going to
that's
say?
no. I mean, I was kind of going to piggyback exactly what you just said, Melissa. Is like I think the picture gets painted that self storage is scary, and we're just trying to get out to get all the tenants, right? And I think there is a fairness balance there, and I love that you called that out, Scott. So talk to us a little bit about like, have there been any national changes or laws or lawsuits that have impacted or affected our industry at the state level?
Well, so it's a good question. So each state has its own statute that governs the operation of self-storage uniquely. And what makes maybe my job most interesting is that there is not just one law that I can teach for every state. Each state, based upon the way the legislators view it, have made up their own laws. So each state is their own mountain to climb to understand what the responsibilities are. And each state, just like you said, may have different rules based upon case law that is decided and judges that interpret those laws differently. Now, we're lucky for the most part that most of these laws are somewhat in a model formation, and we get similar judgments based upon the similarities of the law. But we do get the one-off situations with courts that either uphold or don't uphold certain actions by storage operators. Now, I will tell you that the negative decisions that we've seen in the courts over the last few years have been based upon operators that really are not paying attention to their businesses. So either failing to maintain their properties or allowing criminal activity on their property, including thefts of their tenants' property. When you start getting that sort of gross negligence by an operator, again, in terms of maintaining their property or operating their facility without care and concern for the safety or control of their tenants and their goods, that's where you get liability. That's where judges are willing to put aside the lease and invoke damages for those bad actions. But, look, I'm preaching to the choir here. The folks that are listening on your show are those that really care about their businesses, want to stay up to date, want to do the best to operate their facilities. So obviously, they're doing the right things. It's the folks that are on the fringe, that are operating their facilities, that aren't paying attention to the legal requirements, aren't paying attention to the store. And these are the things that happen and the price that has to be paid. I will tell you, even their insurance companies may not insure them and defend them in response to these actions, because there's provisions in the insurance contracts that say if you're grossly negligent in the operation of your facility or not watching the store and these things are happening, that we're not going to cover you.
So
Wow.
that actually is a good segue, I think, into some of the storm issues that we've seen. Craig has a question on here, lost a fence in a storm, and does that open him up to liability because it's going to be a couple of weeks before that can be put back in place? So how do things like natural disasters impact your responsibility as an operator to maintain security to the best of your ability? I mean, we all know gates break and things like that, but where does something like a natural disaster fall into this piece?
Right. Yeah, and it's something I had a conversation actually with a client this morning. The tenant complained that they should be paid for the damage to their goods arising from the storm that happened at the facility. And my reaction is, you're not God. I mean, you didn't make the hurricane. There's nothing you could have done in response to the hurricane. So there's certain things that are beyond your control, truly acts of God covered by insurance. So in this instance, it's an act of good faith and due diligence in response to the fence repair. Could they do something, or are they trying to do something to repair that fence as quickly as possible? Now I know that there's a line of contractors that are out there already working on other projects that may be hard to get the materials and maybe hard to get the laborers to fix those things. So then the question has to be, what concern do they have that with the fence down, there is a higher risk of potential looting or theft at the facility? And if that's the case, maybe they hire some additional security, add some additional cameras, do something to replace the active security that otherwise would have been in place with the fence. But in terms of grand liability associated with a fence being down and the responsibility to repair it, act as diligently as possible, as reasonably as possible, to get your system and your facility back up to its original condition. If you say, you know what, I'm not going to worry about it, I'm not going to fix it, I'm not going to care about it, if anything happens, I don't care. That's where people get into trouble. If you're showing good faith, look, if you can track that you called the fence company to repair it, but you have to wait a few weeks to get it repaired, that's showing good faith that you're trying to get it repaired.
And so something like if your camera systems are down and you can't provide 24/7, camera surveillance anymore, maybe make changing your access hours to restrict during only daytime, or something that would be a good faith, like I'm trying to protect the property in the absence of this security feature.
Right. And when it comes to these security issues, that's why sometimes this temporary security service can come in as an alternative if your systems are down and your fence is down, and it may be paid for by your insurance company associated with how they want to protect the property. Look, they don't want to deal with claims of theft and damage to their property through the insurance. They may be willing to support that additional cost arising from the storm as an insured loss to you for business operations. So yeah, pick up the phone and call your insurance company. Melissa, great suggestion with regard to limiting the hours. That may be a better solution. Look, you go, run to Best Buy and buy a camera, a Ring camera for an area that otherwise, a camera's not operating. Maybe that's a solution. You're showing good faith by taking those actions.
Mm-hmm.
Mm.
Okay.
Broadly speaking, Scott, like for the folks who might have been impacted, I mean, I've seen some crazy pictures of like the whole entire facility is underwater, for example, right? We have a client in Henderson, North Carolina, outside of Asheville, and their whole facility is just underwater. So, what are tips and tricks that, or advice that you would give these operators and owners and investors to limit their liabilities and protect themselves, but also maybe help their tenants out if possible?
Yeah, it's what a terrible situation. I mean, these catastrophic situations are just awful. There's a dual scenario here. One is the operator's goal of recovering and remediating and repairing its facility, its business, its home of where it does business. So there's a certain amount of work that needs to be done to remediate the property that can't be done while the tenant's property may be in the unit filled with moisture and potential mold and mildew. So there is a duality of contacting the tenants, giving them an opportunity to recover their property or abandon their property, have their insurance companies involved if they're going to make a claim with regard to the loss of their goods in the unit. And it takes time. These aren't solutions that can happen overnight. And each unit has their own story based upon the damage to that particular space, the perceived value of the property in the space. We all know a household good unit compared to a business unit or unique inventory of property. So each unit has its own stories and has to be dealt with. I say it's a process. I know you're in a rush to make the world like it was before the storm, but it's better to take your time, work with your insurance company, work with your tenant's insurance provider or protection plan provider to work through your tenant's issues, have dumpsters available for disposal, but work through it over time. Now, there's going to be a crossroads where the tenant isn't responsive about their property. The unit needs to be removed and disposed of because of its status. It may be a total loss and it does have to be removed, and you're not able to get the tenant to do what they need to do to remove their own property. Work with your insurance company to make sure they're aware and consent to the removal and disposal of that property, because they're going to be on the front lines of the claim and response by the tenant that the property was wrongfully, maybe if they come back, the property was wrongfully disposed of. You'll have the insurance to back you up on hopefully what you have is sale and disposal coverage.
Right. And document everything.
Oh, you've learned.
Yes.
Padawan, you
Hey,
have
I don't know
learned.
how many shows I've listened to you talk, and documentation is huge.
Yeah.
And so
Photos,
take those
photos,
pictures.
photos. Yep, they
Yeah.
take the pictures. Yep,
Yep.
yeah.
Yep. Photos and videos. Okay. So back to our original agenda here. Are
Yep.
there any changes that are trending in other industries that you think could actually spill over to ours?
Yes, yes. Unfortunately, and I feel bad because when I talk about these trends, these legal trends that are impacting other industries that are finding their way to the doorstep of self-storage operators, I feel like the voice of doom because there's a lot of consumer-facing legislation that will impact self-storage operators innocently in terms of how they operate their business. And I'll give you one that happened yesterday. The Federal Trade Commission issued rules with regard to the ease of canceling subscriptions for your Netflix account, that there should be, as easy it is to sign up for your subscription services, it should be as easy to opt out and cancel. Well, what do we have in self-storage? These are month-to-month contracts. Should there be now an easy way to cancel your lease, to vacate? As easy as it is, as many of us make it to become a tenant, now you're going to have to deal with these electronic ease procedures of cancellation. If you look at tenant insurance, which may be,
Mm.
or protection plans, which are offered to customers and maybe even enrolled in customers who otherwise don't meet the insurance proof requirements. If they get the proof or they vacate or they want to terminate, what are the easy options of cancellation or opt out that are in our industry? And I talked to Tommy right here. This happened yesterday, and people are going to be talking to you about your website systems of cancellation and opt out rights. That's on our front door, and it wasn't even us. But the laws will affect self storage operators. The same thing is true with the junk fee laws that came out of California and other states last year that dealt with the issue of hidden fees and deceptive pricing. Well, that was related to the hospitality industry and other, maybe the restaurant industry, not self-storage. But goodness, immediately we're dealing with our website updates to deal with the proper disclosure of all fees in self-storage, admin fees, insurance costs, protection plans, rent. Uh, Goodness gracious. I mean, I worry sometimes that it's the unintended consequences of trying to do good deeds on some of these issues. And I don't want to sound like I'm against consumer rights, but now we have a scurrying effect of operators having to deal with concern over their websites for pricing, concerns over their websites, and operational systems for opt-outs. It's going to be something new every day.
Okay.
Did I just really depress you? Sorry, Melissa. I mean,
No, it's just there's so many things we were just talking about, the difficulty of operating your own business before the show started, because there's so many things you just don't know, especially if you're brand new to owning a business, period. But there's so many things that can come at you from different directions that you don't know to even ask about. And so it's much bigger than it seems.
yeah,
So
yeah.
just
And we're only at the beginning of what might be issues relating to privacy laws and data breach
Mm-hmm.
issues that
Mhm.
affect self-storage operators. We know that self-storage operators have been on the brunt of ADA lawsuits that affected other retail operations that ended up on the door of self-storage operators with regard to screen readers and ADA liability for access, things
Mhm.
that, self-storage operators who otherwise are not operating a retail business fall into the ambiguities of liability associated with these laws. Again, I'm an advocate of ADA protections, but to the extent that it impacts our business operators in self storage, that are unintended impacts on their business. It was not as if anybody built a website. And again, Tommy, you know as well as anybody that would do anything that would impact a visually impaired potential customer. But to be sued over that issue without clarity of the law as how it impacts a brick and mortar business where people store their stuff, and we're not stopping people from storing their stuff. It just becomes, every issue has the potential liability based upon lawyers that pursue those claims, and the ambiguity of the laws that are written by legislators that do not think about the unintended consequences that impact business
Mm-hmm.
operators.
Wow. So let's talk about there's two laws that have happened in the last 12 months, right? You kind of touched on the California one where specifically it was a anti-junk fee law, right? That, like you mentioned, really applied to hospitality, right? Like you're talking about hotels and restaurants and all these fees that add up. So you're buying a $12 thing, and at the end of it you paid $32. And it wasn't disclosed before you gave them your credit card, right? So in self storage, so for the there, I see some California Pug Pack and California members in the audience, so I know that you've dealt with this directly. I know how we have helped out with it. Have you seen any changes or any other, maybe even the REITs? Have they done anything differently since the California laws have dropped?
Oh, I think they absolutely. I think everyone has done it. I think you've seen it in your customers coming to you for clarification that there is sufficient, adequate information to a prospective customer as to what the cost to be a tenant is at the facility.
Mm-hmm.
So if you're charging an admin fee as a mandatory fee, that must be disclosed. that need not be incorporated in the rent. Rent could be rent, but they need to know that to get in the door at your facility, you have to pay the rent, whatever that rent may be. And that raises another question with regard to disclosure of promotions and concessions and rent discounts that may be offered on your website or at your facility, that there's a clarity as to what that discount is, how long it lasts, what it means, how it's created. There's lots of, to create as much clarity as possible. Then secondarily, there you go. So there's a clear reference to the admin fee on the public storage site. There it is on the Extra Space site. So yes, the reaction has been to address these costs as part of the transaction fee of being a tenant. So a tenant who sees $1 move-in doesn't believe they can truly move in for $1 because they're given the full disclosure that it's $1 move in for 1 month, whatever that duration of month may be, either calendar or the remainder pro rata of the month, whatever that may be, plus the admin fee, plus any other required fees or charges. So the answer to your question, your simple question, is a long, gigantic yes. I mean, we are all reacting to that. And if you are an operator that has not yet updated your rental agreement accordingly, I mean, your website accordingly, and your rental agreements with regard to what is mandatory and non-mandatory fees, you need to do that.
Yeah, so we worked with Scott, with Joe, and with Carlos about this, and we sent out an announcement to all the Pug Pack. So if you're in this audience, and of course you're part of the Pug Pack, you've probably already seen that audience or that announcement if you're in California. If you didn't see that and you're in this audience, go ahead and email help@storagepug.com. We want to make sure that you're compliant to our understanding of that law. And if you're not part of the Pug Pack, email your web provider and make sure that your website discloses any admin fees or any required fees outside of the base rent. And in addition to explaining the discounts, like Scott mentioned. The other law that came out in the last 12 months is Florida launched their Florida Digital Bill of Rights. Have you seen that impact self-storage businesses in any way, shape, or form in Florida?
Not particularly. I know it's there. We haven't seen any case law that affects, as far as I know, self-storage operators as a result of it. One thing we did see in Florida, however, as an ancillary element of that, is the law regarding debt collectors, which includes self-storage operators as debt collectors, making sure that you don't send out any notices, bills, collection, lien notices, anything between the hours of 9 p.m. and 8 a.m., knowing that you could be perceived as a debt collector, and that would be a violation of law under the statute. So we've urged operators to reset their notice systems to restrict messages going out to their customers between those protected hours, texts, emails, so that there's no alleged disruption against the customer with respect to the notices.
Thank you. Oh, speaking of Joe, Joe's in the house.
Yeah,
Thank you, Joe.
I was just reading the message.
That's great.
Yeah.
That's great.
That's a great resource, y'all.
Yeah. Okay. Well, somebody was asking about, how do is there a website that displays all the current self-storage laws? There actually is. But also, I'd put this message in the chat, check with your local state association too. And if you don't have a state association, honestly, contact one of your neighboring states. And they can either help you or put you in contact with somebody, or, you can go to SSA.
Yep.
I like Wilson's very first question that he put out here. And I think that kind of rolls well with what we've been talking about. Are there any regulations coming soon or in place around rent raises, either in the amount of the raise or in the frequency that it can happen?
Great question.
So it's great that Joe Doherty from the SSA, their general counsel, is on the call as well, because I mean Joe is the protector of all and self-storage now legislatively. He's the one who's and I sure hope he was on earlier when I gave him all the credit for the state law modernization provisions, because again, it's not happening but for the Self-Storage Association motivating this, the state associations working with the National Association to lobby these changes. So now I lost track. Melissa, you asked your question. I wanted to make.
Are there any regulations
Oh
around
yeah,
rent?
rent. Yeah.
Yeah.
So again, Joe's been battling uh, where they come in on these rent control legislative efforts because the noise that's being made out there from customers about these rent increases. So in reaction to the noise, the legislators have tried to put rent control measures in place in self-storage to control either the number of increases that can happen or as well the percentage of increases that could happen in a self-storage tenant landlord-tenant relationship. So far, the SSA, through their state lobbying efforts, have been able to defeat those provisions. Namely, New York is one example of the pushback to that rent control effort. But Melissa, you raise a general anxiety concern that's out there, which is with all these rent increases happening across the country, is there a risk that the noise will lead to other legislative efforts to create rent control? And the answer is yes. So how do you stop the noise? I'm not suggesting at all that self-storage operators cannot raise their rents. I believe wholeheartedly that the reality of month-to-month self-storage leases gives operators the flexibility of raising their rents to cover their costs and make a living in the businesses that they operate for self-storage. And I know that your real estate taxes are going up, your insurance costs are going up, your labor costs are going up, your legal costs are going up. I mean, it's expensive to be a self-storage operator, and the only way you're going to make a living is how you charge your tenants for those costs. So I'm not against that at all. What I'm against is the surprise and discomfort that your customers may feel if they don't understand and know about rent increases. So does your rental agreement clearly provide that you have the right to change and increase your rent by notice? So please have that in your rental agreement. Does your website clarify in the terms and conditions that rent is subject to change with 30 days notice? Do you notify your customers on any rent concession or concession deals or discount deals that rent discount is only for a limited period of time, and then after that expires, that the higher rate will be into effect? Is it clear so that a customer who's renting from you is not surprised by that jump in rate after the discount burns off? That's where the problem comes. It's the lack of communication. If you're an operator that's sneaking rent increases into your customer, you're the bad actor that people are talking about in the chat that's going to cause us trouble. Everyone wants to blame the REITs on rent increases of how they manage their systems to increase rent. If a customer doesn't want to pay those rents, they don't have to rent from the REITs. They can rent from the mom and pops that are down the street that isn't increasing their rates. It's just the market and how it operates. So don't be upset about the larger companies increasing their rates, but be a good actor about how you communicate your rate increases and your discount programs to your customers. That's how we're going to solve the problem of legislative rent control.
So
No, that's incredible. Yeah.
Kathy's added a question in the chat. Is notifying tenants via text qualify as legal notice? So,
well, the answer is it helps. I like it. It's another added feature of our world that you can communicate by text, but it's not how I would do a rent increase. I would do a rent increase by truly these days, I would send a verified mail letter and an email and a text. Email should cost you nothing. The text costs you nothing. The verified mail costs you $1 or something, for bulk mailing. What's better than being able to respond to an angry tenant who says, I didn't know that my rent went up, by saying, I sent the letter, I sent an email, and I sent a text.
mhm.
Yeah. Good
I
advice.
like it.
So
Yep.
I put a link. So one of the barometers that we kind of observe, like I don't want to say the sentiment of the general public on self storage. One of the barometers is Facebook comments and Facebook threads. Of like, I'm now seeing people just publish on their regular Facebook page, not in these group self storage groups, like it's just on their normal Facebook feed, a terrible experience with self storage. That didn't happen 2 years ago. I'm seeing that pretty frequently now. And then the Reddit has a self storage subreddit, and if you click on the link I said, I mean, the three of the first 10 articles are about bad behaviors, bad actors from the self storage owner side, right? And so I think to Scott's point, like, yeah, don't be the bad actor, and if we
Yeah.
can encourage our people to come and to self storage associations, come to these shows to learn how to do better, then we're gonna get out of the regulation oversight. And I want to answer Jennifer's question from earlier about West Virginia doesn't have a state association. It turns out I know Virginia does, and Virginia's got a pretty awesome state association. I'd imagine the people who run the Virginia one would love a conversation about. I don't know about the rivalry between Virginia and West Virginia, so maybe go talk to Kentucky.
Well,
But
I
I
would tell
think
you that West Virginia operator that contacted you, congratulations, you're now the president of the West Virginia Self Storage Association. And
yeah.
that's all you need. You need a coffee table and an email and invites to your fellow operators. I'll tell you, this is so funny because I literally just came back from the Maine Association, and what great down to earth folks at this meeting. And one thing we all agreed at in this industry that we're in is we're all trying together to make it better. This is not a backstabbing industry. It's amazing how we get folks to sit around a table and talk about trying to do things the right way, trying to make business stronger and better, and working with fellow competitors to make that happen. I guarantee you, you put out an email to the other operators in your community and towns and cities nearby West Virginia, you'll get people to that meeting. You'll all talk about trying to get to the highest tide to make the boats rise, right, in our industry. And as long as you don't talk about pricing, to control the pricing, you're good to go in my book. Talk about
I,
best practices
I
and
love
make
that.
sure you're following the lien law. It's great to do.
No, that's incredible. I here in Colorado, I spoke with one of the founding members of the Colorado Association, and he said that when they first started it, I guess in the '90s, there were two vendor tables and 12 people in
Oh,
their first
wow.
meeting ever. Two
Yeah.
vendors and 12 people, and now I think there's 250 people here in Denver for
But
this
what they didn't
conference
tell you
today.
is those people were all on a ski slope on the way down, drinking hot toddies after the meeting. So that's why the Colorado Association has been so successful.
That's awesome.
Well, yeah, so Jennifer, you're gonna have
Destination.
to really hype up West Virginia and everything that you have to offer.
Love it. Love it.
uh, Scott, thank you. Um, let's shift focus for just a moment. We can't have a legal session without asking this question, right? What are the most common legal mistakes that you're seeing operators make when it comes to just normal everyday operating?
Mistakes are mistakes. It's going to happen. I mean, and I want people to understand that. I mean, as long as you're not ignoring your law and you know your law and you're keeping up to date on your law, these mistakes that otherwise happen innocently. Yes, there may be a price to be paid, but that's why you have insurance. There's things that happen in every business. I mean, I know that every one of us has probably got a shirt back from the dry cleaner that went wrong. Okay, no matter what happens, things happen in businesses. It is the way you handle it that hurts our industry. If you hide it, disregard it, mistreat a tenant in response to it, take responsibility for the mistakes we made. Look, I've had plenty of operators mistakenly sell units. It was not intentional. There was confusion, transcription of the numbers. There was a misapplied payments, and people's property was sold. Okay, that's why you have sale and disposal insurance. Let your adjuster work on the claim. Now, I will tell you, the cover-up is worse than the crime. If you make a mistake, recognize that we've worked very hard to limit your liability contractually with the limitation of value provision in your contract, upheld again with the support of the National Association and Joe and his team to legislatively create the statutory support that if you have a limit of value in your contract, that's the limit of value that you have, that a tenant can have to make a claim. So if there's a mistake made, you get to use the contractual defenses. Yeah, I made a mistake, but your limit of value is $5,000. Now, if you hide your sale, mislead a customer, anything that leads to bad actions after a mistake is made, you're on your own. And people just need to realize that. But that to me is where I see the majority of mistakes made. So I will tell you that my philosophy, as many of you know, is the best sale is no sale. I support your statutory right to enforce your lien law and to sell your tenant's goods. But if you can resolve a customer dispute over money, we're talking when people have disputes over $50. Yesterday, I had a conversation over $85. It's going to cost you more in insurance and lawyers and time to deal with the dispute. Settle that account, let people take their property and write off and move on. That would be my advice. You can take it, not take it. It's your money, and I understand that, but don't sweat the small stuff.
Right, right. So I see a lot about this question. There's some conversation in the chat, and there's also questions about it, and that is active duty military tenants. Yolanda said, for active duty military tenants that go to auction, is there a source where we can go to verify that we are selling their stuff legally and accurately? So can you just speak to the whole SCRA kind of piece there?
Yeah, so there's a federal law that deals with the protection for active duty military and their dependents, that be their spouses or children that are dependent on that military personnel that are, again, on active duty. This is not affecting retired military. This is not someone that is on a National Guard that has not been called up for active duty. So there's very particular guardrails as to who is covered under the Service Member Civil Relief Act for active duty status. The first thing to do is in the rental agreement, you're asking the question whether the tenant is active duty or its spouse or dependents in the lease. And that would be your first sort of red flag that if they go into default, you know that they're active duty, so you stop the sale process based upon the contractual notification. If they did not notify you that they're active duty, but you start going through the default and lien process, and you are then notified that someone is active duty service military, you would stop the lien sale as well and investigate. Now, how do you investigate? So Melissa's right. There is a public DoD website that's you can available. I'm sure Tommy can put it out on the screen, and I can provide it, where you can check with the tenant's information if they're active duty military. And if you want to go deeper into the investigation, there are paid services where they'll provide an affidavit of verification of research as to the tenant's active duty status. And if something is found, you have to stop the sale until you get a court order for approval to sell. And this is really where the settlement issue comes in. I mean, goodness gracious, if they're active duty military, they've fallen behind, and you can settle out the account without having to deal with a court action to sell a tenant's goods, please do that for active duty. That would be the best solution that I can think of. Otherwise, there may be folks that, because of their active duty status, hide behind it and intentionally not pay you and make you go through the steps of court order to enforce your lien rights. So that's what you do. You have to go through the courts to get the court order to approval for the lien sale. There's also, look, and many of you have very active solutions to these issues, contacting base commanders and talking to them about their service members that are assigned to that base and their default of the rent payments. We get a lot of support from the JAG Corps of certain bases to work with us to settle out accounts to avoid a lien sale. But bottom line, Melissa, your question about SCRA, the support weighs in that tenant's favor because of their defense of our country. Treat them accordingly and protect them as well. But if they take advantage of the law, then you have the right. You have a remedy of solution through the courts. In fact, I'll just say this generally because there are these little obstacles along the way in many self-storage relationships with the tenants where tenants will bring up court defenses, domestic defenses, bankruptcy defenses, active duty defenses, and you find yourself battling through a tenant's defense. Don't give up. You have legal rights.
Mm-hmm.
You may want to wait. May want to see how it works itself out, but don't ever feel as if you have no remedy. I can promise you the court systems are frustrating, but there is a remedy to be had through the courts in these sort of situations where you're providing a service to your customers to use your space for the storage of their property. They should pay you. And if they don't pay you, you do have a remedy.
So there's a question in the chat from Anne. What due diligence do you recommend if the tenant is a dependent? What happens when the dependent doesn't provide the service member's information? Like where does that fall in your responsibility versus theirs?
Yeah, see, this is where I get that balance of if they're trying to protect themselves under the law, but don't give you the information to support that protection, then it's just not fair
Mm-hmm.
to be stuck. They're you're providing the service, but you're not getting paid for it. And then they're saying, well, I'm a dependent of active duty military, but then refuse to give that information to verify their active duty status. I would document, just as we talked about, document the communications, the refusal to provide the information. Let time work its way through. But after a due diligence period of trying to confirm a person's status, if you can't confirm their status, I would tell you you'd have the right to proceed to lien. Now, let's work through that scenario. You get sued for a violation of the SCRA by selling an active duty member, but you have the reams of information where you have tried to get that information. Ask them for that information, done your own independent research for that information, and haven't found anything to confirm that their active duty status. You have the right to run your business. You have the right to be paid for your services. I think it'd be very hard for a judge to hit you on a SCR violation where you can show your due diligence of effort to confirm the status and was refused that cooperation.
Okay. Document your efforts.
There we go. Yeah, and thank you for the question. So, Melissa, where should we take it from here? I mean, there's still 12 open questions. I think we should do that, right? Because
Yeah.
I mean, I like the agenda we've got, but we can save those for later when the audience wants
Yeah.
to know these things.
Yeah, let's just
Is that
start at
cool
the
with you?
top.
Yeah, yeah. Start at the top.
Yeah.
So there's another good question from Wilson before the show even started is if a company provides, so Scott, this is going to be probably 18 different directions. So
all right, it's
chop
okay.
and change. So be ready. If a company provides tools for 1099 contractors, can they be held liable if the employee gets or contractor gets hurt while using those tools? Is there anything you need to do to protect yourself?
Well, this gets into a very fact-specific scenario because it is very unusual that a 1099 contractor would use the owner's tools to do their services. Because a 1099 contractor needs to be an independent contractor. And therefore, if they're not providing their own tools and equipment, I'm not sure they're 1099 contractors. So I think that there's a very dangerous line that's being crossed between calling them independent contractors and otherwise where they should be employees and covered under workers' comp. So dangerous steps. An independent contractor should be fully independent. They have their own means and methods and tools and equipment for the services. They should have the ability to provide those services to others other than you. You can't identify and create their schedule unless there's a particular project and a duration that's agreed upon by contract. So I don't want to go down the rabbit hole. I think that's a dangerous twist of facts that you've identified. Independent contractors need to be independent.
Good. Our advice was correct, Tommy.
Hey,
well, you guys stayed at a Holiday Inn last night, so you can answer legal questions. I like
there you go. There you go.
That's exactly right. We took a Scott Zucker course online.
Exactly. All right. So the next one from Wilson is if a tenant is living in a unit, against the terms of the lease, obviously, and a fire occurs, causing them to actually have personal injury, what is the best course of action? The tenant was inherited from a previous owner, and the new owner was not aware that they were living in the unit, and now they've been hurt by a fire that the fire department says was started in their unit.
Oh, goodness. Well, yeah.
Mm.
Um, Look, as long as the operator was not aware that this was happening, this is where no good deed goes unpunished. You
Right.
cannot, as a self-storage operator, in any instance, no matter how sympathetic you are to the situation that has caused a person to choose to live in a storage unit, you cannot allow them to live and stay in a unit. There should be no real loitering at a self-storage facility. It is just for the storage of personal property or business property, not for any habitation use. Now,
Right.
so look, if they didn't know, they didn't know. And if the person living in the space used a space heater or matches or charcoal for a fire to stay warm and caused the injury to themselves, that is an assumption of risk for the person that chose that action, that hidden action that caused that fire.
Mm.
I cannot see any liability. If the operator knew and allowed it, that's a different story. So again, very fact specific issues, but generally, if someone is sneaking onto your property, living in the unit, and lights a fire and hurts themselves in that, that the law supports an assumption of risk against the person who basically hurt themselves. Now, in terms of liability of the fire damage to the tenant's own goods, well, that's again their assumption of risk. For the fire impacting your other tenants or your building, there may be claims against the operator arising from those damages that may be covered by the operator's insurance. It may result in the operator having to try to sue and collect from the tenant who is living in the space, which I understand may be a no-win situation because they're already living in a space. So you assume there's no assets to pay a liability judgment. But there's a lot of arrows shooting in different directions when these sort of situations happen. But for the operator's direct liability associated with the fire, I'd say little or none, as long as they were not aware of the situation.
Okay.
Well, there you go,
Next,
Wilson.
Tommy.
Jaden asked, this is very specific to Pennsylvania. With the updates this year to the Pennsylvania self-storage lien law, is the lease from earlier this year still updated? So, do you know much about the state lease, Scott, for Pennsylvania?
Yeah, as a matter of fact, I think we had a hand in working with the state association specifically in updating the lease. I believe everything's been updated based upon the state law that's been updated. Yes.
Yeah,
Yeah, we've
Jason,
been fortunate to work with the National Association on supporting the state associations with their state standardized leases. So I think we're good to go on most of those states.
I love that. So, Jaden, I would just hit up the Pennsylvania Association. I know they're wrapping up the Mid Atlantic show this week, but I'd hit them up to make sure that you have the latest version of the lease that they publish, and that you're not using an older one. But Scott, I'm glad you're in the know, and you are not only in the know, you were involved. So that's awesome.
There we go. All right. So, next one is Authos. He says a customer supposedly is in bankruptcy, but has not supplied a case number, nor have they made any effort to pay anything. How long can we go before we can start resuming asking for payments?
Well, again, it's just like the SCRA situation. Someone can claim that they're going to file bankruptcy, which means they haven't yet. So they may. They may claim that they did, but really didn't. And I just saw a note in the chat. I think Ann just said that use Pacer. So you have the ability to it's a paid service to go on a federal database service called Pacer and search the bankruptcy uh, logs and database under the tenant's name to verify that they are in bankruptcy. So it's sort of a balance of interests. I certainly would put the burden on the tenant to provide proof, meaning the case number that they filed for bankruptcy, maybe their lawyer's name and number as well, so you can verify the bankruptcy. If they're unwilling to do that, you can check under their name through Pacer. If nothing shows up, you should respond back to the tenant, hey, there's nothing here. Unless you provide me proof, I am proceeding with our lien rights. And then you have the right to proceed until they provide you such proof. And again, talking about remedies, even in bankruptcy, there's ultimately an action to get relief from the stay that's imposed as a result of the bankruptcy to allow you to sell the tenant's goods. So even if a tenant files bankruptcy to avoid a lien sale, ultimately, if you want to pursue the right of recovery through the lien, there is a court remedy to do that. Yes, there's a lawyer involved and there's costs and time involved in doing that. But if you show your intent to proceed to enforce your rights, maybe your tenant and their lawyer will work out a resolution with you.
There you go, Otto.
Yeah.
Hopefully that
There you
helps.
go.
Yeah. James, oh, I like this question. So, James, your question was actually an agenda item that we didn't get to. And there's been a lot, I don't want to say mixed advice, but we've heard multiple versions of this. And so James asked if you have storage units and it has AC, but no heat or no humidity, are you allowed to display or sell these units as climate controlled units? So if you only have air conditioning, but no heat or no humidity, can you call these climate controlled storage units?
Well, if you're providing air conditioning in, I'm trying to think, air conditioning in a state that is otherwise hot. I'm trying to picture like you provide air conditioning in Arizona.
There you go. Thanks, Ann.
Yeah, I just said, I don't think operators use heat in Arizona to create a controlled climate in their building. They're more worried about the air conditioning than they are the heat. Here's my answer to that confusing question anyway, is what is climate control? There is no definition by law of the term climate control. So the only way to identify what you are advertising is to define the term that you are advertising. So if you offer climate control, your rental agreement should define what that means, and your website should define what that means. Does that mean you are only doing temperature control? Does it mean you're only doing air conditioning? Does it mean you may only be doing heating? I've heard facilities that are only doing I forget the term. That's some sort of ventilated heat system that's neither HVAC oriented or not. So the answer to it is whatever you define as climate control in your rental agreement and website is what your customer would therefore be entitled to rely on when they're renting from you. So if you want to advertise climate control, but clarify that your climate control means air conditioning only, then do that because you're not hiding anything. You're transparent about what you are using as your definition of climate control.
Scott, that's so cool. 7 years of doing this, I've never heard that. I didn't know that there wasn't a legal definition of climate control, and I didn't know that you can more define it yourself on the lease and on the website. Because the general convention that our clients come to us with is like, hey, we don't offer true humidity or heat or whatever, so we don't want to use climate control on the website. And we always just abide because it's fine, right? And so they usually swap it out with AC storage units or temperature controlled or what have you. But
which I'm fine with as well. It's just the fact that sort of our industry has used the phraseology climate control to suggest that there is some sort of temperature control going on in the building. But I could tell you, and everyone here knows this, none of you can control the climate, right? Just think about it. Climate control. What the heck does that mean, right? It is not, there's no control of our climate, or there wouldn't have been 2 hurricanes in 2 weeks. So it is a defined term for your facility and transparency to your tenants to know what they're getting for the value of what they're paying.
But whether you're using climate control or temperature controlled, either one of those should be outlined in your lease agreement and explain exactly what that means.
Yeah, I go further than that. I will have a climate control provision in my rental agreements that also clarifies that you're not providing any warranties or guarantees associated with the provision of those services. Sometimes the power goes out, the systems won't operate. Tenants can't rely on what you are trying to offer, because sometimes what you're trying to offer can't be offered based upon the circumstances. So yeah, the terminology climate control is always a dangerous one. I see that Eric is identifying some articles that are out there that deals with this issues. So, again, transparency and clarity to your customers is what I'm looking for an operator.
Love
Okay.
that. James, great question, man. Thank you for asking.
Yeah, I like it. Okay, this is a different question that Rhonda has put in here. What rights do self-storage owners and managers have to conduct biannual or annual inspections on their rented units? We recently dealt with a tenant abandoning 856 waste tires in a 10 by 40
Ooh.
unit. An inspection would have allowed us to observe what's being stored, and prohibit that kind of thing. So, are there rights for our owners to do inspections?
Well, the answer is yes. I mean, in your rental agreements, you do have the right of entry for the purposes of repairs and emergencies and inspections. You would have that right. Do I encourage you to do that? No. I mean, the more you stay out of your tenants' units, unless they're leaking or smelling or something that would trigger a concern about the unit, or obviously if they're in default, there's really no reason to enter, again, unless there's an emergency or repairs or something like that. Could you establish a calendar for inspections of your tenants' units and notify them of those inspections? Absolutely. I, you know, I, I think that people find these dump units when they find these dump units. I mean, typically, if you're really following your lien law, you'll have the right of a lock cut and inspection for default of payment, within typically, no less than 45 to 60 days in most states, some as early as 30, some as early as 15. So, I mean, you're going to find out if a unit's been used as a dump site on the early stages. I don't know whether regular inspections are the solution to that problem. Now, they may be a solution to the risk of water intrusion, mold and mildew of an unknown condition at your facility, a leaky roof, opening in the flashing, something that may cause water intrusion that you wouldn't otherwise know about unless you did regular inspections. But my sense is that you can accomplish that without going into a tenant's unit. You can do your roof checks. You can do your walkthroughs. You can look for evidence of water intrusion in your building. You can do the smell site test to see if anything's going on in your properties. I mean, Melissa, you can answer that. I mean, do you think we should be doing inspections?
No. No, I think the the less you know, the better sometimes. No, I feel like you're gonna open a can of worms. And I think a better approach to that would be having management that is very active on site so that when tenants are on site, you go out and walk past their units, say hello, take them a bottle of water, and then you are evaluating their unit while you're standing there. And when you see something that looks off, you can address it. I think that's a better inspection performance than actually holding inspections, because then I look at that almost like a liability. What if I'm talking, I'm saying I do regular inspections, but then I don't catch someone who's living in a unit or storing explosives? And is that not going to come back on me and say, well, you were supposed to be inspecting these units and you didn't catch it, so now you're liable for the fire that broke out or whatever. So I don't, it's
Yeah.
self-storage. Let them store it themselves.
Yeah. No, but just so, and I agree with everything you're saying. I want people to understand that it's not as if they don't have the right of going into a tenant's unit, because the contract gives them that right as a landlord to make sure the property is being used for the purpose it was rented for. And if there's an emergency, they can go in. Obviously, I always want them to give notice to a customer before they enter the unit. So it's all about notice. But I don't want people to be afraid of going in. Now, what I will tell you is, on a flip side, a little bit, is we have added a mold and mildew provision in our updated leases that requires the tenant to do a periodic inspection of their unit. Because what we don't want is a
Mm.
situation where a tenant has dropped their stuff in a space, they don't come back for 2 years, and then suddenly go, oh, my stuff's got mold and mildew. And if they had discovered it with reasonable inspection of the property, within a month of recognizing the condition, they could have removed it, cleaned it, whatever themselves, and they wouldn't be claiming that it's the landlord's problem. So we want to put the burden on the customer to do the inspection themselves.
Right. Right.
That's solid. Wow. So, Melissa, it's 3:05.
It's that time already.
It's
Oh
that
my
time already.
gosh.
We have 8 open questions. So, Garrett, if you're still listening, which I think you are, let's catalog all the unanswered questions so we can ask them in a future, either a pop-up event or we can
Yeah.
even save them for next year's legal session. And let's also catalog all the unasked questions from our agenda because I think we have another hour at least worth of content.
We really do.
We really do. We really do. So I want to ask today's question of the week, though, Scott. Let me share my screen here. Question of the week is, what is the most important piece of legal advice you'd give any storage business owner?
Wow, what a trick question. All right. Other than make sure they have the best lawyer that they can get. Is
There you go.
yeah. That honestly, the answer is have a good rental agreement. Whether it's me or Jeff or Carlos or anyone else out there doing rental agreements, whether you buy them online through services that we support, get a good rental agreement because that's your line of protection for a storage operator with regard to compliance and protection. And really, that's your operational Bible for self-storage is that rental agreement complying with your state law. So that's the best advice I can give. As well as everyone should be listening to the Gabfocus every time you do a session.
And stay off of Facebook. Don't ask Facebook your legal questions.
Please don't ask Facebook your legal questions. Honestly, Melissa, that's another hour's worth of content.
Yeah.
We can put on our lawyer hats and go through the Facebook questions.
I would love that, and I
Yeah.
love what Carly just said. Don't use Chat GPT to write a rental agreement.
Oh yeah.
You.
Also,
Yeah.
don't. Yes.
Oh,
Thank you, Carly.
yeah. Please
Oh
don't. Please
boy. Oh
don't.
boy. Oh boy. Scott, I want to ask because I can't remember the URL. What's the URL if I wanted to go online and buy a storage rental agreement? I know you're involved, and I know Carlos is involved. So this can be a plug and it's transparent. But
Sure.
what is that URL so I can
Sure.
put it in the chat?
That's www.storageleasenow.com.
There we go.
Storageleasenow.com.
I couldn't find the URL, but I knew it existed. So this is pretty cool. You can generate a lease online. I don't think it's very expensive. It's a one-time fee, couple $100, few $100, and you get the lease. And there you go. But like Scott said, get a good attorney that you can afford, and make sure that your lease is rock solid. Scott, man, thank you, sir. 37 years in the industry, and you still have the energy to do this, to share your expertise and your time. That warms my heart. How can people get a hold of you outside of storageleasenow.com? How can people get a hold of you if they have more questions or want to hire you as their attorney?
Well, yeah, happy to help anybody who needs it. They can reach me at scott@wzlegal.com. Our website is wzlegal.com. Also offer that they should look at joining the Self-Storage Legal Network, which is selfstoragelaw.com. And that's a member benefit of the National Association and state self-storage associations. So think about maybe joining that. You ask a question, unlimited question, you get email responses through the portal on the National Association website. So hopefully that's something very helpful for operators out there as well.
Yeah, I love getting I don't know, I can't recall if it's monthly or quarterly, but I love my little self-storage legal network update that the association mails out. So, y'all, thank you. Of course, this episode and every episode is available online, all past sessions, storageplug.com/resources. And Josh will be uploading this to the Gabfocus Self-Storage podcast in no time. In fact, it looks like he's already got a link up there. And next up, November's episode, Marketing That Gets Clicks. This one's going to be a really fun one. We're entering the official slow season, and it feels like a lot of operators never even got the busy season this year. I met some operators here in Denver that Yeah, they didn't get any more rentals in July and August than they did in
Mm.
February. So we're going to talk about some marketing ideas that helps get clicks, gets eyeballs on your storage business, and whether it's a down season or an up season. So be ready for that. We'll send out the announcements for registrations here in the next few weeks. But Scott, thank you again, friend. I don't think I'll see you in because your next stop's New Hampshire.
No, no,
Um,
no. I'm done with New Hampshire.
oh,
I
you
actually,
just got back from New
my
Hampshire.
next one is Detroit. I'll see any of you that live in Michigan. Hopefully, see you at the State Association meeting in November.
George Pug will be there. I'll miss out, but Alex will be up there for the Detroit show. So we'll see you when we see you. But Scott, thank you
Okay.
again, my friend, for coming out.
Thanks for the invite, guys. Good to see you both.
Thank
Thank you.
you.
All right.
Appreciate
Thank
it.
you.